Hello, everyone. Welcome to SAVEDNews TV. I am your host, A.Z. Hubbard, and I want to thank you so much for allowing me into your homes today because, like I always say, you did not have to do it. Well, today we're going to cover the case of Archbishop Bernard Jordan versus Larry Reid et al. Now, before we get into the meat of this case, I want to say over here at Save News TV, we have no position, absolutely none. We will be reporting only on the case and the facts. Now, if you all are interested in us, keeping up with this case beyond this video, please let me know in the comments. If there is no demand for it, we will not do it. Now, this case started in February legally, but there has been a lot of things going on in the background over the course of several months, over a year. What we will not be doing over here on Save News TV is going through the things that have been going on as far as um, giving commentary on the messiness of it all, because this has been very messy from the inception of this particular case. As many people know, Archbishop Bernard Jordan was the mentor of Larry Reid for approximately 5 years. And so, what we're going to do over here, like I stated, we're going to go only by the case. Now, as we know by all of the other things that we have covered over here, just because someone brings a lawsuit does not mean there are facts. And just because um, the it's been reported in a lawsuit doesn't mean anyone is guilty or not guilty of the situation. As we have stated, and as the law states, anyone can file a lawsuit. It is up to the courts to determine and to sort out what is truth and what is not truth. Okay. And also, I want to, before I really get into this case and begin to read this case, I want to bring up a scripture because I think it's important as we start seeing a lot of this happening more and more in Christendom. The Word of God in Matthew 5:25 says, "Reconcile quickly with your adversaries while you are still on your way to court. Otherwise, he may hand you over to the judge, and the judge may hand you over to the officer, and you may be thrown into prison." Now, I'm saying this not just for um, those that's listed in these lawsuits, but also the bloggers and vloggers that are out here making commentary. Okay. So it's important that we stick to the facts. I know some people, they're team this or team that. Over here on Save News, like I stated, we are team nobody. If you go back to all of our videos where we've covered court cases, we are team nobody. Now, we do inject commentary as far as what we feel that the law is. Again, we are not lawyers, attorneys over here. We are not. This is no legal advice. But we also will let you know this or that. Okay? We will let you know what this is or what that is. Remember, all of these are allegations in this court case. All right? Now, first, we're going to read the actual complaint. We're going to read the amended complaint because there's an amended complaint on the 13th of February. Also, we're going to go over a few of the motions that has happened. There has been an order, there's been a letter, and there's been an order on jurisdiction. And we'll go over that later. The reason why we're going to go over the complaint is because even though the jurisdiction has changed, which I just gave you a spoiler, um, the complaint probably pretty much will be the same or very, very similar. Okay. So that just happened. So let's now get into the actual complaint. All right. Let me share my screen. Okay. So as I stated earlier, this is there has been several actions that's gone on in this case. And as you can see quickly here, briefly, what we're going to go over is the amended complaint. We're going to go over the order, the letter, and the order. All right. So let's get to it. Okay. So we have this amended complaint was filed on February 13th, 2026. And it is Archbishop Bernard Jordan is the plaintiff versus Larry Reid, D. Reid individual, and doing business as Larry Reid Live, Justin D. Edwards, Calvin R. Blake Sr., Devon, Davion Augustus individually and doing business as Consciouz TV, Marcellus McMillan individually and doing business as Mad Church Disease, Tyesse Jackson individually and doing business as the Tyesse Report, James Singletary, Kendall Peacock, Chamaco Bryant, and John Jane Doe's 1 through 10. So we're going to stop here. I'm going to talk about a little bit of this. Number one, they need to amend the complaint again because I do not believe that Tyesse Jackson is his real government name, even though he does DBA as the Tyesse Report. Number two, as we all know over here on the Saveite crew, that John and Jane Doe's 1 through 10 could be anyone that they want to list later on and add to the complaint. So they've left the options open for there to be other defendants in the case. Okay. Let's get into it. Okay, plaintiff Archbishop Bernard Jordan, plaintiff, or Archbishop Jordan by and through his attorneys, Nessenoff and Miltenberg, LLP, as and for his complainant against defendants Larry D. Reid individually. We've already named these. We're not going to go over that. We're going to skip some if we can because this is it's only 36 pages. This action arises from defendants' orchestrated campaign of unlawful surveillance, non-consensual recording, and intentional dissemination of recording of Archbishop Bernard Jordan, followed by the publication and monetization of false, defamatory, and highly invasive statements concerning plaintiff's private life. Plaintiff is a nationally recognized minister with more than 4 decades of pastoral leadership, public teaching, and media presence. His credibility, moral authority, and reputation are foundational to his vocation, ministerial standing, and the trust placed in him as by faith-based communities nationwide. Defendants Larry Reid, Pastor Justin Edwards, and Calvin Blake engaged in deliberate, non-consensual disclosure, commercialization, and amplification of the plaintiff's private sexual information across multiple digital platforms, including behind paywalls, for financial gain and notoriety. This coordinated conduct caused profound reputational destruction, severe emotional distress, and significant harm to Archbishop ministry and professional relationship. The misconduct at issue includes, but not limited to, the unauthorized recording and public disclosure of private facts, defamation per se, civil conspiracy, and revenge porn adjacent activity, all carried out with the knowledge of plaintiff's identity, standing, and vulnerability to reputational injury. Plaintiff's professional and pastoral life depends upon the integrity, confidentiality, and the sanctity of pastoral communities and mentorship relationships. Defendant conduct directly undermine these core principles, inflicting lasting harm that cannot be redeemed absent jurisdictional intervention. So let me say this from the onset about this case. One thing that I am noticing regarding a lot of these commentaries is that they are focusing solely on the salaciousness of what is inside of, or not inside, allegedly inside of the recordings itself. They're focusing on the defamation. But this lawsuit clearly states out that it is about surveillance, non consensual recording, and intentional dissemination of recordings of Archbishop Jordan. So, even though there is a part of this case regarding defamation, even if those facts were proven to be true, okay, because we know truth is a defense to defamation, that does not address the surveillance, the non consensual recording, and the intentional dissemination of recordings. So, this is a multi layered lawsuit. And as we get into it more, we'll find out other things that is breaching and touching on criminality that could graduate from just a civil case into a criminal case or cases. Okay, so let's move on. Excuse me, the parties. Plaintiff Archbishop Jordan is a nationally known religious leader, author, and clergy figure with the decades long public ministry. Plaintiff is a resident of the state of New York, at all times relevant to the complaint. Defendant Larry Reid was and is a media personality who operates an online platform, Larry Reid Live. Upon information and belief, Dr. Reid resides in the state of Georgia. At all times relevant to this complaint, defendant Pastor Justin D. Edwards served as senior pastor of Holy Cross Baptist Church South in Chicago, Illinois. Upon information and belief, Pastor Edwards resides in the state of Illinois. At all times relevant to this complaint, defendant Calvin R. Blake Sr. was an individual initially hired as a driver for the plaintiff in connection with a speaking engagement at a church in Houston, Texas, and who therefore maintained contact with the plaintiff. Upon information and belief, defendant Blake resides in Houston, Texas. At all times relevant to this complaint, defendant Davion Augustus was an individual who operates a YouTube channel called Consciouz TV. Upon information and belief, defendant Augustus resides in Columbia, South Carolina, and operates his media business, Consciouz TV, out of Columbia, South Carolina. At all times to this complaint, defendant Marcellus McMillan was an individual who operates a YouTube channel, Mad Church Disease. Upon information and belief, defendant McMillan resides in California, and operates his media business, Mad Church Disease, out of California. At all times relevant to the complaint, defendant Tyesse Jackson was an individual who operated an YouTube channel, the Tyesse Report. Upon information and belief, the defendant Jackson resides in the state of Georgia and operates his media business, the Tyesse Report, out of Georgia. Again, I state that his government name is not Tyesse Jackson, and they need to, but by them tying it to the show, the Tyesse Report, which he hosts and he owns, then it steals, and also they're covered by the John Doe 1 through 10 John Jane Doe thing. Okay. Defendant James Singletary is an individual who appeared as a guest and made defamatory public comments regarding the defendant that were broadcast and republished by co-defendants. Upon information and belief, defendant Singletary resides in the state of Georgia. At all times of the complaint, defendant Kendall Peacock was an individual who edited and altered illegally obtained audio recordings involving plaintiff and distribute such altered recordings to online bloggers and media personalities. Upon information and belief, defendant Peacock resides in the state of Georgia. At all times relevant, the complainant, defendant Chamaco Bryant, was an individual who was present during playback sessions of the illegally obtained recordings and participated in private discussions furthering the conspiracy against the plaintiff. Upon information and belief, defendant Bryant resides in the state of Georgia. Defendants John Jane Doe 1 through 10 are individuals whose identities are presently unknown, who assisted, facilitated, leaked, or republished illegal recordings or defamatory content concerning plaintiff. Plaintiff will seek leave to amend this complaint upon discovery of their identities. Jurisdiction and venue. We're going to skip through this because there it has been a ruling on the jurisdiction. So okay. Because they're talking about there's been a ruling on this. Let's get to the statements of facts, the background. Plaintiff Archbishop Jordan is a nationally known, recognized minister. Okay, we just went through that. Throughout his ministry, plaintiff has adhered to strict ethical standards governing pastoral counseling, mentorship, and confidentiality. His professional and pastoral relationships depend on credibility, discernment, and sanctity of private communications. Over the course of his ministry, plaintiff maintained a consistent record of ethical leadership and pastoral responsibility and did not engage in any inappropriate sexual conduct. Plaintiff and defendant Edwards had a close personal relationship. However, it did not involve coercion, compensation, or any exchange of value. When it became apparent that Edwards' motives were financial and inconsistent with the plaintiff's values and boundaries, plaintiff ceased communications. At no time did plaintiff compensate Edwards for intimacy or engage in prostitution, solicitation, or any form of transactional sexual conduct. Any financial assistance plaintiff provided was charitable and pastoral in nature. Edwards gained access to plaintiff through positions of trust and proximity created by the plaintiff ministerial role. In furtherance, a pastoral support, plaintiff provided limited financial assistance to Edward and his spouse, including covering vehicle payment when they lacked reliable transportation necessary for ministry work. Plaintiff also retained and paid for legal counsel for Edward's son, who became involved in a legal matter. These actions were undertaken philanthropy and as an extension of pastoral care. After Edwards revealed his true intentions, plaintiff discontinued and terminated all such assistance. Consistent with his long-standing ministry practice, plaintiff routinely provided mentorship, excuse me, guidance and charitable support to individuals engaged in faith-based or ministerial support. Such support was offered as an act of pastoral care philanthropy, not as a part of any quid pro quo arrangement. After plaintiffs terminated the relationship, Edwards, acting in concert with defendants Reid, Blake, and others, engaged in conduct designed to retaliate against plaintiff, extract financial benefit, and damage plaintiff's reputation. Defendants' subsequent actions included the secret recording of the private communications and dissemination of other recordings and publications to distorted or false narratives concerning plaintiff's private life. Defendants undertook this conduct with knowledge of plaintiff's identity, vocation, and severe and foreseeable harm such disclosures would inflict upon his reputation and ministry. At all relevant times, plaintiff had a reasonable expectation of privacy in his communications, relationships, and pastoral interactions. Defendants knowingly violated that expectation. Defendants coordinated with one another, and with third parties to amplify these disclosures across multiple media platforms, including subscription-based and paywall services, converting plaintiff's private life into content or profit and leverage. As a direct and proximate result of defendant's willful and malicious conduct, plaintiff has suffered substantial reputational harm, emotional distress, professional injury, and dis- disruption of long-standing ministerial relationship. Conflict with defendant Reid. Reid was formerly a mentee of plaintiff for approximately 4 to 5 years. During this relationship, Reid publicly acknowledged paying approximately $3 million in contributions to the plaintiff's ministry. The conflict involved defendant Reid originated in October 2024 during the United States election season, when Reid stated publicly that Archbishop Jordan supported a specific candidate. The assertion was false and made without evidence. Throughout his ministry, Archbishop Jordan was careful to not publicly endorse any political candidate, because his parishioners represent both Democrat and Republican beliefs. And I think this is a smart thing. People, you know, in certain positions, and not just that, your vote or your position, if you want it to be private, it should be private. Um, that's just the way it should be. Okay. This rift marked the significant public shift in the relationship between the plaintiff and the defendant Reid. Defendant Reid was formerly the mentee of plaintiff and held himself out as a devoted follower, confidant, and beneficiary of the plaintiff's pastoral guide. Plaintiff extended mentorship, access, and spiritual counseling to Reid in reliance on that relationship of trust. Defendant Reid cultivated a close relationship with plaintiff over a period of years, positioning himself as a trusted mentee and insider. Plaintiff relied upon the representation in extending access, guidance, and support. Upon information and belief, Reid publicly acknowledged that he had made financial contributions and offering to the plaintiff's ministry over the course of their relationship. Such contributions were consistent with plaintiff's longstanding ministry practice and were not personal payments to the plaintiff. Upon information and belief, Reid's relationship with plaintiff deteriorated after the plaintiff declined to meet Reid's escalating financial expectations and demands, which were inconsistent with the plaintiff's values, ministry practices, and fiduciary responsibilities. Following that departure, Reid made various public statements characterizing the relationship and plaintiff's conduct in the manner plaintiffs allege was false, misleading, and retaliatory. After the fallout, Reid began making statements, both publicly and through intermediaries, intended to recast plaintiffs' charitable and pastoral support as improper, transactional, or exploitative, despite knowing such characteristics were false. Now, everybody, I'm doing a lot of reading today. I got to drink some water. Um, Stick with me here. Shortly after Archbishop Jordan participated in a private White House meeting with African American faith leaders in May of 2025, online commentary directed towards plaintiff increased dramatically. Following that meeting, third-party content creators and commenters began circulating insinuations and speculative narratives concerning plaintiff's personal conduct, frequently referencing, republishing, or paraphrasing statements attributed to defendant Reid or individuals acting in coordination with or at the encouragement of defendant Reid, including defendant Edwards. These narratives established the groundwork for a broader defamatory campaign and were later leveraged to amplify and legitimize false accusations following the unlawful recording and dissemination of plaintiff's private communication. The illegal recording and interception of plaintiff's communication. On November 4th, 2025, defendant Edwards initiated multiple telephone communications with plaintiff who was in New Jersey at the time. Defendant Edwards was physically located in Illinois. At approximately 3:58 p.m. on November 4th, 2025, defendant Edwards called plaintiff. The conversation later lasted approximately 1 hour and 2 minutes. During the phone call, Edwards transmitted to the plaintiff a photograph of himself and defendant Reid and referenced a, quote, story, unquote, allegedly being prepared by plaintiff while denying any involvement about the plaintiff, while denying any involvement. The conversation quickly turned confrontational and hostile, and plaintiff communicated that the relationship was ending due to Edwards' conduct and inappropriate language. Later that evening at approximately 9:55 p.m. on November 4th, 2025, defendant Edwards attempted another brief call lasting approximately 18 seconds. At approximately 9:56 p.m. on November 4th, 2025, Defendant Edwards initiated another call with plaintiff lasting approximately 45 minutes. This call consisted constituents constitutes this call constitutes the central event giving rise to the civil and criminal liability. Listen, everybody, when you're reading a lot, it all runs together. Be patient with me. During the call at 9:56, Defendant Edwards merged Defendant Reid into the call without disclosing Reid's presence and without obtaining plaintiff's consent. For the entirety of the call, plaintiff was unaware that Reid was present or recording the conversation. Defendant Reid has since admitted that he was located in Dubai, United Arab Emirates, that he was merged into the call by Defendant Edwards without plaintiff's knowledge or consent, and that he recorded the conversation without plaintiff's knowledge or consent. Now, I'm going to stop here because we're going to get into it more later in this video. By Reid being in Dubai, the United Arab Emirates, that is a major problem because it is a criminal offense to record someone in Dubai without their consent. And we, like I said, we will go over that part later as we break down some issues in this case that we see as laymen in this case that could be detrimental to either party. Let me put it that way. Reid admitted that he recorded plaintiff's conversation with Edwards in a public broadcast dated October 15th, 2025, prior to the November 4th call. Defendant Reid stated the following: "There's someone else that has come to me by night. They were not coming to me to be messing. But because they were lied to, they thought they could come to me about their truth and the truth of my former mentor. I recorded every conversation and told them I recorded that every conversation." Okay. In Reid's private members-only broadcast, he has made even more explicit admissions about the existence and the use of these recordings and admitted using these recordings to support his public accusations. Now, I want to come back up here. He said, we want to look at the dates here because this looks strange. Now, this call, one of the calls in questions was on November 4th, 2025. But then on October 15th, which was prior to November 4th, Reid said that he recorded these calls. So the question is, did he record the November 4th call? Okay. That would be up to the jury because they requested a jury by trial to make that determination whether Larry Reid continued, was he still in Dubai on November 4th, and was he still recording all of the phone calls? Okay. Let's get back to this. It's on audio. It's on my audio. I can tell my truth about what I was told about Justin. I can tell. I can tell that, and he can tell another story or edit story, but the audio verifies what I'm saying. Defendant Reid's public admission demonstrates that the November 4th recording was not accidental or isolated, but part of a broader pattern and practice of intentionally recording private communications without consent. Okay, so that just answered my question. If this, what is written is true. Remember, everything in a lawsuit are just allegations until proven. Okay. Upon information and belief, Defendant Edwards and Reid coordinated the November 4th call and subsequent recordings in advance with the intent of capturing plaintiff's private communications for later use, dissemination, leverage, and monetization. At all relevant times, plaintiff had reasonable expectations of privacy in his telephone communications. Defendants knowingly and intentionally violated that exception in violation of federal and state law. And right here, again, um, like I stated, this is, this might need to be renumbered because, not just federal and state law, this was international law. If Larry Reid was indeed in Dubai, and if Larry Reid indeed recorded the conversation without Bishop Jordan's knowledge. Excuse me. The independent illegal recording by Defendant Blake. On November 26, 2025, Defendant Blake sent an email to Defendant Reid referencing the recorded communications. In this email, Blake stated, "I have been helping a friend who he groomed and violated many times all the way until recent as weeks ago. The last convo they had was out of the blue, and I was with my friend and I recorded the entire exchange." So now we have another party that is recording conversations. Where was Blake located? Allegedly. Therefore, plaintiff became aware that Defendant Blake recorded a private telephone conversation involving plaintiff without his knowledge or consent. On December 6, 2025, Consciouz TV confirmed the existence of the recording on the Here We Go Again King Jives broadcast, because there's a lot of people who's got audios, right? Larry got an audio. Bishop Blake got audios at approximately 2 hours and 2 minutes and 44 seconds. The plaintiff was physically located in New Jersey at the time of this conversation. Defendant Blake, who was physically located in Houston, Texas, at the time of this conversation. Okay, so they're answering these questions that I'm asking. Remember, I'm reading this in real time, and I'm asking the questions that you all want to know. Drop the comments in the section. Plaintiff did not consent either expressly or impliedly to the recording, interception, or preservation of the conversation, and had reasonable and legally protected expectations of privacy in the communication. Blake's written admission that he, quote, recorded the entire exchange, unquote, with plaintiff demonstrates that the recording was intentional, knowing, and undertaken without plaintiff's consent. Thereafter, Defendant Reid forwarded Blake's email and its contents to third parties, including defendants William McCray and Tyesse Jackson, intentionally distributing information derived from unlawful recorded private communications beyond the original participants. Okay, now they put defendant William McCray, but he is not listed in the lawsuit as far as a defendant. Like I said, the attorney for Bishop Jordan need to tighten some of this up because William McCray is not listed as a defendant. And also, Tyesse Jackson is not his real name, his government name. That is the name of his show. So these are a few things that need to be tightened up by the attorney that represents Archbishop Jordan. And we're going to, like I said, we'll discuss a few of these things in our extended commentary. Upon information and belief, the recording of Defendant Blake was shared, referenced, and relied upon by the defendants and their associates as part of a broader effort to collect, circulate, and exploit plaintiff's private communications. Excuse me. The coordinated defamation campaign and conspiracy. Beginning on and about December 2025, defendant and their associates released online content referencing purported emails, audio, and private conversations, thereby representing that they possessed and relied upon materials obtained through unlawful interception and recording. On December 6, 2025, defendant Augustus, through his Consciouz TV platform, published a video entitled Larry Reid Live, The Cover-Up, Bishop Bernard Jordan Exposed, Emails and Audios Shocking. During the Consciouz TV broadcast, the following defamatory statements were made, claiming that the plaintiff was engaged in extramarital affairs, speculating about his sexual orientation, and allegations of tax evasion and stalking and harassment that were not true. Okay, so it goes on. At approximately 1 hour, 27 minutes, 11 seconds through 1 hour, 28 minutes, and 22 seconds, multiple audios exist of Bishop Bernard Jordan exposing his extramarital affairs with a man. I'm not going to go through these time frames. You can look at it on the screen if you want to go back through it. We have proof, audio proof, of Bishop Jordan's affair with his male lover and the male mistress called the wife. Graphic descriptions of sexual acts allegedly performed by plaintiff, including vulgar references to sexual position and acts. Bishop owed the IRS $400,000. Bernard is distressed about money. We learned this from the audio. He is gang stalking the person, calling church members, friends, harassing them, manic, obsessive, weird behavior. And egregious during the broadcast, false statements about plaintiff's sexual orientation and allegations of molestation attributed to defendant Singletary were read aloud, including at approximately 2 hours, 13 minutes, 36 seconds to 2 hours, 17 minutes. Bishop has been queer his whole life. It goes back 40 years. Ask Isaac Jordan. Bernard molested him. This was known by ex-Zoe members. His nephew was molested by his personal assistant. The accusations of molestation, grooming, criminal sexual conduct constitute defamation per se under applicable laws. The broadcast contained numerous false statements, false implications, and defamatory narratives concerning plaintiff, including but not limited to accusations of criminal sexual conduct, sexual misconduct, financial improprieties, and abuse of power. During the broadcast, defendant and their collaborators made graphic, salacious, and sensualized statements purporting to describe plaintiff's private sexual conduct and personal favors, frequently asserting that such claims were supported by, quote, audio, unquote, or, quote, recordings, unquote. Defendant Singletary made further defamatory statements accusing plaintiff of sexual abuse, grooming, and targeting young boys, claiming that the plaintiff's ministry is fraudulent, corrupt, and demonic, and that the plaintiff is bipolar, mentally erratic, and unstable. These claims were presented as facts with no basis and unequivocally false. Such statements by defendant Singletary constitutes defamation per se. Defendant Macmillan, through his Mad Church Disease platform, published multiple videos discussing plaintiff in a defamatory manner, including videos dated October 17th, 2025, December 1st, 2025, and December 2nd, 2025, which amplified harmful narratives derived from illegally obtaining recordings. Among the most egregious statements aired were allegations that the plaintiff had engaged in grooming, molestation, and criminal sexual abuse, assertions that plaintiff had concealed such conduct for decades, and claims that plaintiff engaged in systematic harassment and financial misconduct. These statements were false and were presented as fact. Plaintiff unequivocally denies all such allegations. The accusations of molestation, grooming, and criminal sexual conduct constitute defamation per se under applicable laws. The defamatory publication were viewed hundreds of thousands of times collectively and caused severe and ongoing harm to plaintiff's reputation, ministry, professional standing, and emotional well-being. Defendants Reid, Blake, Ed, Edwards, Augustus, McMillan, Jackson, Singletary, Peacock, Bryant, and Does 1 through 10 acted in concert and conspiracy to unlawfully intercept and record plaintiffs' private communications, share and disseminate such unlawful obtain recordings and derivative information, publish false and defamatory statements concerning plaintiff, and maximize reputational, professional, and personal harm to plaintiffs for leverage, retaliation, notoriety, and financial gain. The coordinated nature of the defendant's conduct is evidenced by, among other things, timing and sequencing of their publications, the sharing and references of unlawful obtained recordings and communications among defendants, the forwarding of emails and messages explicitly referencing the recorded conversations, the cross promotions, repetitions, the amplification of defamatory consent across multiple platforms. Defendants knew or recklessly disregarded that their statements were false, that the materials they relied upon were unlawfully obtained, and that their conduct was foreseeably caused catastrophe, harm to the planet. Plaintiff's damages. The unlawful recording of the plaintiff's private conversations and subsequent dissemination of defamatory statements based on these recordings, viewed hundreds of thousands of times collectively, has caused severe and ongoing harm to plaintiff's reputation, ministry, professional standing, and emotional well-being. As a result, the defendant's actions, plaintiffs have sustained and will continue to sustain reputational harm. As a result of the defendant's actions, plaintiff has sustained and will continue to sustain damages related to future professional opportunities in his ministry. As a result of the defendant's actions, plaintiff has sustained and will continue to sustain damages related to emotional and psychological distress, including anxiety and loss of reputation. Plaintiff has required professional counseling and therapy services to address these injuries and has incurred substantial medical expenses. As a result, defendants' actions, plaintiff's ministry experienced significant financial loss, including the reduction of church membership of approximately 60%. As a result of the foregoing, plaintiff seeks relief for damages caused by defendant's actions and inactions, all of which will permanently alter the trajectory of plaintiff's reputation, personal and professional relationships. Now, we're going to stop here for a second and interject that some people say, well, how did he have mental emotional and psychological distress? I recall, like I said, I'm not going to go through the messy on this show about what has happened in the past on, prior to this. But I do recall a video where Archbishop Jordan was on St. James' show, and that he stated that he had been in therapy due to the um, Larry Reid and the situation that has happened. So there has been there's a record of that publicly, but I'm sure also that if he's sought professional help and therapy, that they will also be able to produce medical records. Also, some I've seen people say, well, how can he show that there has been approximately 60% loss of church membership when Bishop Jordan's ministry is online? Well, you can look at financial records, you can look at attendance, as far as how many people are watching the show. It's easy to track those types of things. So now we're going to get into the claims for relief. Violation of federal wiretap Act 18 USC 2511 against defendants Reid, Edwards, and Blake. The plaintiff repeats and realleges the allegations set forth in paragraph 1 through 96 and is fully set forth herein. The Wiretap Act affords a civil cause of action to an aggrieved individual who has had his oral communications intentionally intercepted by a party to those communications for the purposes of committing a crime or tort. The statute requires that an oral communication be intercepted for the purpose of committing any criminal or torturous act. Defendants intentionally intercepted plaintiff's wire communication for the purpose of circulating damaging and defamatory information about the plaintiff's private life and for the purpose of extorting and monetizing for recording in violation of federal wiretap. Unbeknownst to plaintiff on November 4th, 2025, defendant Edwards merged defendant Reid into a telephone call with plaintiff without disclosing Reid's presence. Plaintiff, who was located in New Jersey at the time of the conversation, was unaware that Reid was present on the call with Edwards, who was located in Chicago, Illinois. Defendant Reid recorded the entire November 4th, 2025 conversation from Dubai. Again, um, excuse me, this is a violation of international law for Dubai for this to happen, but this is the United States, so I don't know whether they plan on pursuing something in Dubai because it's an arrest. Well, I'm not going to give it away, but I'll, in the commentary at the end, more detail, I will show you what we're talking about regarding Dubai. Plaintiff did not consent to the recording on November 4th, 2025 conversation. Defendant Reid has publicly admitted to recording the conversation, stated, "I recorded every conversation and told them I recorded every conversation." Defendant Blake recorded a separate private telephone conversation with plaintiff without his knowledge or consent. Plaintiff was physically located in New Jersey at the time of the conversation with Blake. Defendant Blake was physically located in Houston, Texas at the time of the conversation. Plaintiff did not consent to either expressly or implied to the recording, interception, or preservation of the conversation with Blake. On November 26, 2025, Defendant Blake sent an email to Defendant Reid stating, "I have been helping a friend who he groomed and violated many times, all the way until recent as weeks ago. The last convo they had was out of the blue, and I was with my friend and I recorded the entire exchange." Blake's written admission demonstrates that the recording was intentional and knowing. Defendants disclosed the contents of the intercept communication to third parties. Defendant Reid forwarded Blake's email and its contents to third parties, including Defendant Jackson and others. Defendants intentionally used the content to intercept communications in online broadcasts and publications. Defendants' interception, disclosure, and use of plaintiff's wire communication violates Section 2510. Defendants utilize the recordings of plaintiff's wire communications to monetize, excuse me, from false, defamatory, and highly evasive statements concerning plaintiff's private life, including his brief consensual relationship with defendant Edwards. Defendant further used the recordings of plaintiff's wire communications to amplify plaintiff's private sexual information across multiple digital platforms, including behind paywalls for financial gain and notoriety. This coordinated conduct caused profound reputational destruction, severe emotional distress, and significant professional harm to plaintiff. As a direct and proximate result of defendant's violations, plaintiff have suffered substantial harm to his reputation, emotional distress, and professional injury. Count 2, violation of racketeering, influence, and corrupt organizations. Woo! RICO. RICO. Ho, ho. Oh, let me get a sip of water. So now, what this lawsuit is doing is shifting it from civil to criminal. In this lawsuit, can trigger the DOJ to look into this communications and allege communications and what Archbishop Jordan is alleging that transpired regarding these communications, even to the point where they can reach in Dubai and have an impact there. But again, we'll go over that later. RICO is a very serious charge, okay? Plaintiff repeats and realleges the allegations set forth in paragraph 1 through 119 as if fully set forth herein. Section 162, 1962C of 18 USC makes it unlawful for any person employed by or associated with any enterprise engaged in or activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprise affairs through a pattern of racketeering activity. Now, you might say, well, how is there, I can understand interstate AZ, but I don't know where you're coming from with foreign commerce AZ. Well, if during which time or at any time from the time of the recordings that Larry Reid was in Dubai and made a video, or if he was on a program, or if he went in his members only, did a live, and received monetary gain through talking about these alleged recordings, and he, like I said, he gained financially, that is considered foreign commerce. Even though he's a resident of the United States of America, he did it in Dubai. So there's another layer to the Dubai incident that we'll talk about later. Okay. To establish a civil RICO claim for violation, a plaintiff must show 1, conduct, 2, of enterprise, 3, through pattern, 4, of racketeering activity, 5, that has caused injury to the plaintiff's business or property. To demonstrate a pattern of racketeering, a plaintiff must show that at least 2 predicated acts committed in a 10-year period. And according to Archbishop Jordan, he has outlined a minimum of 2 on these situations here, allegedly. A RICO damages plaintiffs need allege only that it has suffered an injury directly resulting from some or all of the activities comprising of the violation. Therefore, as long as the plaintiff can sufficiently plead proximate injury resulting from the wire fraud conduct, they will have met the injury requirements of RICO standing. So, like I stated earlier, Archbishop Jordan had established through a recorded broadcast when he was a guest that he was receiving therapy based on this situation. This was, I don't recall the date on the St. James show. Also, he stated in this pleading that approximately 60% of his congregation has left, showing a financial damage, allegedly. But again, these things have to be proven. But these are the things that he's saying that meets the RICO damages. Defendants conducted and the affairs of an enterprise through a pattern of racketeering activity. The enterprise consists of a coordinated group of defendants acting in concert to unlawfully intercept, record, disseminate, and monetize from plaintiff's private communication. Defendant Reid, Edwards, and Blake associated together for the common purpose of engaging in a course of conduct that included unlawful interception of communications, wire fraud, and dissemination of unlawful obtained materials. The enterprise engaged in and affected interstate and foreign commerce through the use of telephone communications across state lines and internationally, and through the dissemination of content via internet platforms accessible nationwide and internationally. Defendants engaged in a pattern of racketeering activities consisting of multiple predicated acts. The predicated acts violated of 18 USC 2511, the Wiretap Act, which constitutes predicate acts under 18 USC 1961. The predicated acts include wire fraud through the use of interstate wire communications to further a defamatory scheme and conspiracy of recording, disseminating, and monetizing private information regarding plaintiff's private life. On November 4th, 2025, defendants Edwards and Reid used interstate wire communications to unlawfully record plaintiff's private conversation with Edwards, where they discussed their private consensual relationship. Defendant Reid was located in Dubai, United Arab Emirates, during the recording. Defendant Edwards was located in Illinois doing the recording. Plaintiff was located in New Jersey doing the recording. Defendants used interstate wire communications to disseminate unlawfully obtained recordings to third parties. So they're showing where everybody was to prove the alleged interstate and the alleged international foreign. So defendants use internet platforms to publish and monetize derived from unlawful obtained recordings. The pattern of racketeering activity is evidenced by the timing and sequencing of the defendants' publications. The pattern of racketeering activity is evidenced by the sharing and referencing of unlawfully obtained recordings and communications among defendants. The pattern of racketeering activity is evidenced by the forwarding of emails and messages explicitly referencing recorded conversations. The pattern of racketeering activity is evidenced by the cross promotion, repetition, and amplification of defamatory content across multiple platforms. The pattern of racketeering activity is evidenced by the monetization of plaintiffs' private lives through subscription-based and paywall services. The pattern of racketeering activity is further evidenced by the intentional galvanization of bloggers with anti-plaintiffs agenda and testimony from participants describing the coordinated nature of the attack. The evidence establishes a coordinated campaign involving documented financial transactions, subsequent deployment of operatives, insider testimony confirming the conspiracy's structure and objectives, and self-identified, quote, ringleader, unquote, whose stated goal was to, quote, end, unquote, plaintiff. Woo! That's a whole lot. The predicated acts were related to each other and demonstrated continuity. The predicated acts occurred over a period of months from October 2025 through December 2025 and continued thereafter. Defendants coordinated to monetize for these communications through paywalls and subscriptive services. Plaintiff was injured in his business and property by reason of defendant's violations. Plaintiff has suffered substantial reputational harm to his ministerial standing and professional reputation. Plaintiff has suffered emotional distress as a direct, excuse me, as a direct result of defendant's conduct. Plaintiff has suffered professional injury and disruption of ministerial relationships, including ministry revenue decline and the loss of church members. The defamatory publications were viewed hundreds of thousands of times collectively, causing widespread harm to plaintiff's reputation and ministry. Count 3, defamation per se, against defendant Davion Augustus. Plaintiff repeats and realleges the allegations set forth in paragraphs 1 through 152 as if fully set forth therein. To state that the defamation under New York law, a plaintiff must allege false statement about the plaintiff published to third party without authorization or privilege through fault amounting to at least negligence as part of the publisher that either constitutes defamation per se or cause special damages. A defamatory statement is one which exposes an individual to public hatred, shame, obloquy, contumely, ottoman, contempt, ridicule, aversion, obstruction, degradation, or disgrace, or includes an evil opinion of one in the minds of right thinking persons and deprives one of confidence and friendly intercourse in society. A plaintiff is not required to plead special harm if he alleges that the defamatory statement, 1, accused him of a serious crime, 2, tend to injure another in his trade, business, or profession, or 3, include a claim that plaintiff has a loathsome disease. A public figure plaintiff must prove that an allegedly libelous statement was made with actual malice, that it was made with knowledge that it was false, and with reckless disregard of whether it was true, false, or not. On December 6, 2025, defendant Devon Octavius, through his online platform, Consciouz TV, broadcast and published a video entitled Larry Reid, The Cover-Up, Bishop Jordan Exposed, Emails and Audio, Shocking. During the broadcast, Augustus made the following statements concerning plaintiff. Multiple audios exist of Bishop Bernard Jordan exposing his extramarital affairs with a man. We have audio proof that Bishop Jordan's affair with his male lover. Bishop owed the IRS $400,000. Bernard is in distress about money. We learned from this audio. He is gang stalking the person, calling church members, friends, harassing them, manic, obsessive, weird behavior. Augustus further published a video containing graphic descriptions of alleged sexual acts purportedly performed by plaintiff. These statements were presented as factual assertions, not opinions, satire, or rhetorical hyperbole. Each of the foregoing statements was false, and the plaintiff did not engage in the misconduct described in the broadcast. The statements expressed identified plaintiff by name and were understood by recipients as referencing to plaintiff. The broadcast was published through YouTube and related online platforms and received hundreds of thousands of times and viewed hundreds of thousands of times. The statement constitute defamation per se because they accused the plaintiff of serious criminal conduct, including sexual misconduct and molestation, imputed sexual misconduct and immoral behavior incompatible with his role as minister, and tended to injure plaintiff in his trade, profession, and ministerial calling. The statements were not substantially true in any respect. The plaintiff is nationally recognized minister and public figure. Defendant Augustus acted with actual malice. Augustus possessed recordings of the plaintiff's private conversation, and disseminated them with the intent to construct and publish a false narrative concerning plaintiff's sexual orientation, alleged criminal conduct, and financial improprieties. I had to get a tissue. Augustus knew the statements were false and acted with reckless disregard of their truth or falsity. Augustus relied on unlawfully obtained recordings and deliberately ignored contrary evidence demonstrating the falsity of his allegations. Augustus intended the publications to cause reputational, professional, and financial harm. As a direct and proximate result of Augustus' defamatory publications, plaintiffs have suffered substantial reputational harm. Plaintiff's ministry experienced financial losses, including reduction of the church membership of approximately 60%. Plaintiff suffered harm to his ministerial standing and professional relationship. Plaintiff suffered severe emotional distress. Okay. Count 4. We almost done, y'all. Well, we're 2/3 there. Plaintiff defamation per se against defendant James Singletary. Plaintiff repeats and realleges the allegations set forth in paragraphs 1 through 173 as fully set forth here therein. Okay. On December 6, 2025, during the same broadcast, defendant James Singletary appeared as a guest and made the following statements concerning plaintiff. Bishop has been queer his whole time. This goes back 40 years. Ask Isaac Jordan Bernard molested him. These statements were presented as factual assertions. Each statement was false, and the plaintiff did not engage in conduct described. The statements expressly identified plaintiff by name and were understood by recipients as referring to the plaintiff. The statements were broadcasted through YouTube and other online platforms and viewed by hundreds of thousands of recipients. The statements constitute defamation per se because they accuse the plaintiff of serious criminal conduct, including molestation and sexual abuse, imputed sexual misconduct incompatible with his ministry, and injured plaintiff in his trade and profession. These statements are equivocally false. Plaintiff is a nationally recognized minister, public figure. Singletary acted with actual malice. Singletary knew the statements were false and acted with reckless disregard for the truth and or falsity. Singletary made the accusations without any factual basis and with awareness of probable falsity. And as a direct and proximate result of Singletary's defamatory statements, plaintiffs suffered a reputational, professional, financial, and emotional harms described above. Count 5, defamation per se against Marcellus McMillan. Plaintiff repeats and realleges the allegations set forth in paragraphs 1 through 186 as if fully set forth therein. Excuse me. Child is reading. On October 17th, 2025, December 1st, 2025, December 2nd, 2025, defendants Marcellus McMillan published videos concerning plaintiff through online platforms including YouTube and related media. In those videos, McMillan made statements including but not limited to the following: that the plaintiff engaged in sexual misconduct with men, that plaintiff engaged in criminal sexual conduct, including molestation and abuse, that plaintiff ministry was fraudulent, corrupt, and deceptive, that plaintiff engaged in unethical or criminal financial practices, that plaintiff was mentally unstable, bipolar, erratic, or dangerous. These statements were presented as assertion of facts, not opinions, rhetorical hyperbole, or commentary. Each of the foregoing statements was false, and the plaintiff denies engaging in the conduct described. The statement expressly identified plaintiff by name and were understood by recipients as referring to defendant. The videos were published to third parties via online platform and were viewed by a substantial audience. The statements constitute defamation per se because the accused plaintiff of serious criminal conduct, including sexual abuse and sexual abuse and molestation, imputed sexual misconduct incompatible with his ministerial position, imputed professional misconduct and fraud in his ministry, intended to injure plaintiff in his trade profession and ministerial calling. The statements were not substantially true in any respect. Plaintiff is a nationally recognized minister and public figure. McMillan acted in actual malice. McMillan knew the statements were false or acted with reckless disregard for their truth or falsity. McMillan repeated and amplified allegations that lacked factual basis and ignored obvious reasons of doubt their accuracy. McMillan intended to harm plaintiff's reputation and professional standing by publishing and republishing such accusations. As a direct and proximate result of McMillan's defamatory publications, plaintiff suffered reputational harm, professional injury, financial loss to his ministry, and severe emotional distress. Count 6. Against defendant Larry D. Reid and Justin D. Edwards, dissemination of private telephone recording. Defendants repeats or realleges paragraphs 1 through 201 as if fully set forth therein. Defendants Reid and Edwards disseminated recordings of Edwards' private phone conversation with plaintiff to third parties. The recordings were disseminated in a manner that conveyed and implied that the plaintiff, we went over this, engaged in extramarital sexual relationship with men, criminal sexual conduct, fraudulent or unethical conduct in his ministry, engaged in improper financial conduct. The dissemination of these recordings was accomplished by commentary and framing that asserted the truth of these accusations. The implications and assertions conveyed through the disseminations were false. Plaintiff did not engage in the conduct suggested or implied. The recording expressly identified plaintiffs and were understood by the recipient as referring to plaintiff. Reid and Edwards distribute the recordings to third party without plaintiff's authorization or privilege. The recordings were further republished and broadcast through online platforms to substantial audience. The dissemination constitute defamation per se because it imputed serious criminal conduct, sexual misconduct incompatible with plaintiff's ministry, the professional fraud. Implications conveyed were unequivocally false. Plaintiff is a nationally recognized, public figure, recognized minister and public figure. Reid and Edwards stated with actual malice because they knew or should have known the information was unlawfully obtained and acted with knowledge of falsity to damage the plaintiff's reputation. Woo. They recorded the plaintiff's private conversations, and disseminated them with the intent to construct and promote a false narrative concerning plaintiff's sexual orientation, alleged criminal conduct, and financial improprieties. They knew that the narrative being promoted was false and acted with reckless disregard for the truth and or falsity. They intended that the recordings be used to damage plaintiff's reputation and professional standing. As a direct and proximate result of the dissemination of the recording, plaintiff suffered reputational injury, professional harm, financial loss to his ministry, and severe emotional distress. Count 7. Civil conspiracy against Larry Reid, Justin Edwards, and Calvin R. Blake Jr. Plaintiffs repeats and realleges the allegations set forth in paragraphs 1 through 218 as if set forth therein. To establish a claim of civil conspiracy, plaintiff must demonstrate the underlying tort plus the following 4 elements: the agreement between 2 or more parties, the overt act of furtherance of agreement, the parties' intentional participation in the furtherance of a plan or purpose, and resulted in damage or injury. Defendants Reid, Edwards, and Blake enter into an agreement to accomplish an unlawful purpose. Defendants Reid and Blake agreed to unlawfully intercept and record plaintiff's private communications. Reid and Edwards agreed to share and disseminate such unlawful obtained recordings and derivative information with third parties who utilize the recording as part of YouTube broadcasts. Reid and Edwards agreed to publish false and defamatory statements concerning plaintiff. Defendants agreed to maximize reputational, professional, and personal harm to plaintiffs for leverage, retaliation, notoriety, and financial gain. Defendants committed overt acts of furtherance of conspiracy. On November 4th, 2025, defendant Edwards and Reid coordinated to merge Reid into the telephone call with the plaintiff and record the conversation without the plaintiff's consent. Defendant Blake recorded a separate conversation with the plaintiff without consent. On November 26, 2025, defendant Blake sent an email to defendant Reid referencing the recorded communications. Defendant Reid forwarded Blake's email to third parties, including defendants Jackson and others. On December 6, 2025, defendant Augustus published a video containing false and defamatory statements about plaintiff. Defendant McMillan published multiple videos amplifying harmful narratives derived from illegally obtained recordings. The coordinated nature of defendants' conduct is evident by the timing and sequencing of their publication. The coordinated nature of defendants' conduct is evidenced by the sharing and referencing of unlawfully obtained recordings and communications among defendants. The coordinated nature of the defendant's conduct is evidenced by the forwarding of the emails and messages explicitly referring to the recorded conversations. The coordinated nature of the defendant's conduct is evidenced by the cross promotion, repetition, and amplification of defamatory content across multiple platforms. Plaintiff suffered injury and damage resulting from the conspiracy. As a direct and proximate result of the conspiracy, plaintiff have suffered substantial injury to his reputation, ministerial standing, emotional well-being. Plaintiff have suffered professional injury and disruption of ministerial relationships. The defamatory publications were viewed hundreds of thousands of times collectively across widespread harm and causing widespread harm to plaintiff's reputation and church membership. Count 8, intentional infliction of emotional distress against defendants Larry Reid, Justin D. Edwards, Calvin R. Blake Sr. Plaintiff repeats and realleges the allegations set forth through paragraphs 1 through 240 and set forth herein. In cause of action of the intentional infliction of emotional distress, IIED, under the New York law, the plaintiff must plead and prove the four. We're going to skip this part because this now has been moved from New York. The jurisdiction, New York court said they did not have jurisdiction, so we cannot bring forth this part. We'll go over when Archbishop Jordan refiles, then we will go over this part here. So we're going to skip this part because this includes the New York law. Now, to the other good part of any lawsuit, the prayer for relief. So you say all of that to say, this is what I want. So that's what a prayer for relief is. So let's get into it. Wherefore, the plaintiff Archbishop Bernard Jordan respectfully requests the court enter a judgment in favor and against defendants as follows. On the first cause of action of violation of Wiretap Act 18 of the USC 2511, a judgment awarding plaintiffs damages in the amount to be determined at trial, but in any event, no less than $10 million, including without limitations, damages to reputation, loss of professional opportunities, loss of ministry revenue and future revenue, emotional and psychological damages, plus prejudgment interest, attorneys' fees, expenses, costs, and distribution. Excuse me. One thing that I know, I'm gonna stop here because there's, it says it in every one, that a lot of people are missing when they read this case is the prejudgment interest. Now, each state has interest accumulated on a judgment. So if they're asking for prejudgment interest, that is substantial. So some states, depending on the length of the judgment, some states is 7 years, some states is 10, 12 years, but the interest rates varied from 5-7% up to 15%, might be more or less depending on the state. But that interest accrues depending on the state, some daily, some monthly. So a $10 million judgment with prejudgment interest, it just could, every day, every moment, every second that the judgment isn't paid in full, just the amount is just exaggerated even more. So I wanted to touch on that. The second cause of action for violation of racketeering, influence, and corruption, which is the RICO, a judgment awarding the plaintiff damages in the amount to be determined at trial at another $10 million. Same thing. Um, in the third cause of action, defamation per se against defendant Davion Augustus, a judgment awarding the plaintiff to be determined at trial, but no less than $10 million. Same stipulations. Fourth, defamation per se, cause of action against defendant James Singletary, a judgment awarding plaintiff in the damages in the amount determined at trial, $10 million. This is what they want. On the fifth cause of action, defamation per se, Marcellus McMillan, the judgment or damages amounting to be determined at trial, but no less than $10 million, same conditions. On the sixth cause of action, defamation per se, defendants Larry D. Reid and Justin D. Edwards, a judgment awarding plaintiffs damages in the amount of trial, but no less than $10 million, same conditions. The seventh cause of action, the civil conspiracy for judgment awarding the plaintiff damages and the amount to be determined at trial, but no less than $10 million. Same conditions. On the eighth cause of action, intentional infliction of emotional distress and judgment, awarding plaintiff damages to be determined at trial, but in any event, no less than $10 million. And same conditions. Demand a jury trial. Okay, so that's what we have with that. Now, let's get into some of the areas that could be problematic that this case need to be tightened up, or some admissions or whatever the case might be, um, before they file in New Jersey or to make amendments to this case. All right, hold tight, everybody. We're going to look at this right now. Let's discuss. Okay, so we're going to get into the commentary part briefly and um, talk about some of the things in this filing that we know now that has been, the venue has moved to New Jersey. And so I'm just, I showed you earlier the sequence of the venue being moved, so we won't go over and read that. There was a jurisdiction issue and it has been moved to New Jersey, the case. Now let's go over some things that we see immediately that's obvious to us. Again, this is not legal advice. We are not attorneys. We don't know, but these are just some layman armchair um, observations. Okay. So first off, we want to highlight that Tyrese Jackson is not his government real legal name. He is DBA Tyesse, the Tyesse Report. So that is covering the DBA. But what they, I don't know legally how this would play into if you are suing someone and you do not have their full correct and accurate name. Okay. Um Again, we know that the John and Jane Does 1 through 10 open up the opportunity for anybody else that they might find to add to the lawsuits during discovery or prior or after discovery. Okay. We also want to highlight the, I want to do this in sequence because I want to spend more time on the Dubai situation. Um, Also, as far as the Tyrese Jackson, nowhere in the pleadings do they identify what Tyrese Jackson evidently, the Tyesse Report evidently said or did. Um, in this case, allegedly, he's just named. And also, when it comes down to the prayer of relief, he is not named in any of the prayer for relief. Let's go down in the amounts of which they are suing him. They, name other defendants, but they did not name um him either here. So that is one thing. Also, we want to go in here and see if we can find the, which I said earlier, and do a search in this document. They named William McCray as a defendant. However, let's see if I can find it. This is just so much stuff here. Is there a way to search in this document? Ew. I'm not seeing how to search in this document, but I should have highlighted it they did name, and when I was reading it, I did go over it, that they named William McCray as a defendant. However, they did not name him at the top in the pleading. Okay. I'm not finding it, but it's in here somewhere. Okay, so now for the other part that I wanted to talk about, and that is a lot of people are focusing mainly on the defamation part of this lawsuit. But one thing they're not really talking about is the RICO and the part that is international, and that is the part of defendant Larry Reid allegedly being in Dubai when these allegations started. So what I'm going to do is I'm going to share my screen here and show you the law in Dubai. And of course, I used our trusted friend, Chat GTP. So we're going to go over, excuse me, what the law is in Dubai. In Dubai and the United Arab Emirates, UAE, overall, the law generally makes it illegal to record another person's private conversations, images, or personal data without their consent. In doing so can lead to criminal penalties. This applies to both audio and video recordings taken privately, even if you are part of the conversation. Key legal principles in Dubai, the UAE: consent is required. You must have explicit consent from the other person or all parties before recording audio or video of them, especially in private or intimate settings, including phone calls and in-person conversations. A two-party, all parties consent rule is generally applied. Everyone involved must agree. And these are the sources that it's given me also. Cybercrime and privacy laws. The Federal Decree Law number 34 of 2021, cybercrime law, specifically prohibits eavesdropping, interception, recording, photographing, or disclosing a person's private communication or information without permission. Violations can lead to fines and imprisonment. For example, penalties under Article 44 of the Cybercrime Law can include fines of approximately AED 150,000 to AED 500,000 and potential jail time. Other related laws. The UAE Penal Code and statutory provisions also criminalizes unauthorized interference of with a person's individual's privacy, including recording or transmitting private conversations without consent. Illegally sharing or disseminating such recordings, even after capturing them, may be separately punishable. Recording conversations. Recording phone calls without informing and obtaining consent of all parties is generally illegal and can be prosecuted whether for personal use or as evidence. Even if you participate in the call, you still need the other person's permission to record it. Recording in public. Even though this isn't, you know, applicable to this case, but we're going to read it anyway, just in case you decide to fly over to Dubai and need to understand what the law is there. Recording in public. In some limited contexts, such as taking video for police evidence of a crime or reporting to authorities, the UAE has indicated that capturing footage, e.g., via official apps for police reporting, may not be penalized as long as it is not publicized or misused. But this exception does not mean, they put it in bold, does not mean blanket permission to film people generally without consent. Consequences of illegal recording. Criminal penalties, fines, and possible jail times for privacy violations. Confiscation of devices used to make the recording. Recordings may be inadmissible in court if obtained illegally. Practical takeaways. Before you record somebody in Dubai or anywhere in the UAE, always ask for clear consent. If recording phone calls, notify participants and ideally get verbal or written agreement first. Avoid posting or sharing any footage without permission. When in doubt, seek legal advice or rely on official authorities to handle evidence collection. So then it asked me if I want other articles. So anyway, I wanted to highlight that there are severe penalties if indeed defendant Larry Reid was in Dubai when he made these recordings. Now, some people ask, well, what will happen? Will the Dubai or the UAE go after him? I don't know. It could Archbishop Bernard Jordan contact the authorities there? Absolutely, yes. Well, what if defendant Larry Reid is reported and he flees back to America or, comes back to America, or he goes to another country. Well, there are things called extradition laws. So if Dubai decided that they wanted to pursue, if reported to Dubai and the UAE regarding these recordings, and if Dubai wanted to pursue them, then they can, if defendant Larry Reid is no longer in the UAE Dubai, then they could request extradition from whatever country he is in. Now, there are few countries that do not have extradition laws. They will not extradite, but um, most countries will send you to whatever country to face whatever charges that you have pending in that country. So I wanted to just touch on that. And there'll be other things, like I said, most importantly, I wanted to say is that, again, we just report on the facts here. We do not have a dog in this fight. We are team nobody. We are team Jesus Christ. We are team Jesus Christ. So if you are interested in this case, please comment below, because as you see, this is a long video. That's a lot of reading. It costs money to get the court cases, and there's no sense of me investing money and investing time if you are not interested in this case. If you are coming over here for the messy, this is not the channel for you as far as cases are concerned. We report the news. We do not get into messy. We give commentary. We give our opinion, try to be non-biased, fair, down the middle. Are there things that some of these defendants can do? Of course, they can ask to be severed. Just take me from the rest of these people, and I want to stand alone. I want a standalone case. They can also, of course, they can try to negotiate, any of them, negotiate and get a settlement, to settle this without going to court. Of course, they can do that also. There are other options, and they can stand up and fight it and say, hey, I am innocent of what you're accusing me of. I did not do any of this, and you need to show proof. Are there ramifications for Bishop Jordan? Of course, it's called discovery. And when it comes to discovery, it's not just him getting information from them. They'll also be able to get information from him. Can this case be detrimental to all parties involved? Absolutely, yes. A court case should be the last resort. I don't know the circumstances. I don't know the thought pattern. Is it a mistake for them to bring the case? I don't know. Some people are saying it is. Some people are saying it isn't. I don't know. It is really up to that person and whether they want to stand and fight one way or the other with this case. And it is up to the individual on how they handle it. Should they seek legal advice? Absolutely, positively. Should they, again, I'm not, like I said, we are not lawyers over here. We are armchair giving our commentary. And we know for a fact, again, we're not covering the messy. We know for a fact that there are those that's listed in the complaints that are speaking publicly. And you ask, should they be speaking publicly? They should consult their attorney. Their attorney probably would advise them against speaking publicly regarding this case, or the attorney might say, go ahead. Or the attorney might release a statement, or the attorney might give them a statement to read and release themselves. I don't know. I am not an attorney. I am not their attorney. It is up to them to seek legal and professional advice. So again, anyway, everybody, there are other things in this lawsuit that could be that we can go over, but I have spent enough time on this without knowing whether or not you all want more information on this case. Let me know in the comment section. Please like, share, and subscribe, and tell me what you want. Tell me what you want. But anyway, everybody, I appreciate you so much for tuning in to Save News TV and rocking with me through all of this. And you have a very blessed and prosperous day. Bye.
I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear. For every tear he's ever near. Choirs rise on Sunday morn, his love we adorn. Each melody a testimony, hearts reborn. In every